We are joined by one of the lawyers who has been adversely mentioned for having engaged in social media judgment and also trying to influence, and that is what this president of the Supreme Court tried to say. But moving away from that, is what is the import of this judgment that has been delivered today?
Thank you. I believe what the people of Kenya want to know today is whether the Constitution of Kenya Amendment Bill 2020 has seen the light of day, whether reggae has been halted or it will continue. The Supreme Court has, on the basis of two grounds, declared as unconstitutional the BBI bill and agreed with the High Court and the Court of Appeal insofar as that bill was declared unconstitutional. These were the two grounds. First, the Supreme Court agreed both with the High Court and the Court of Appeal that the BBI bill was not a popular initiative for the reason that it was commenced by the President, who does not hold the position of a citizen under the Constitution of Kenya. Number two, the Supreme Court has agreed with the High Court and the Court of Appeal that there was no adequate public participation insofar as the initiation and the promotion of this bill is concerned. To that extent, therefore, we can say affirmatively that today marks the end of the BBI bill insofar as it has been declared unconstitutional.
But what about the question of basic structure? Does that not, or rather did your case not suffer a blow where that is concerned?
Well, a soldier is armed with a rifle, a bayonet, a grenade, and a penknife. If you are able to obliterate your enemy with your penknife, then you cannot lament that you didn't make good use of the rifle. And perhaps it is a manifestation of the bottom-up approach. We started with many issues before the High Court upon which this bill was declared unconstitutional. Those issues reduced as we went to the Court of Appeal. In the Supreme Court, they have now converged into two fundamental issues. So I can say without any fear of contradiction that today's decision is an epic decision, is a monumental historical decision for the benefit of the people of Kenya. It underscores the fact that the people are the ultimate authority insofar as constitutional amendments are concerned. It also emphasizes one thing: individuals cannot constitute themselves into Wanjiku, Wamboi, Kamau, Onyango, Nasimiu, and say this is what we want for the people of Kenya. There must be adherence to what the Constitution provides insofar as what is good for the people.
Well, but then also there are these other issues that have been allowed, and that is the issue of the basic structure, as she has said, and all that. Does that now give a window for the promoters, probably because there are those who believe that the promoters were not the president and all the others? Yet, though it might have fallen on that particular one, but there are those who believe that there is a window that has been presented for them to probably revive this.
A window?
No, we do not even have a window, let alone a crevice. This is what the judges have said, and fundamentally my law lecturer, Dr. Smokin Wanjala, that these are concepts, they are doctrines of law that are yet to attain the status of a norm. And those issues can only be discussed in a classroom, in the teaching of law. But that may be perceived from a very erroneous perspective by those who have hope that there is hope for the BBI bill to be revived in the near future. Well, what the court has said today is that there are no limitations as to what you can do on account of amendments of the Constitution, save for the parameters set out by the Constitution itself. Can this thing be revisited in future? Of course, yes. Whoever is desirous of pursuing the amendments that were restricted and cut off on account of the basic structure may want to do that in future. But time-wise, is it of any impact insofar as the general election is concerned? Zero impact.
Well, you know, most of the things that have been happening, including the president, has been very categorical, noting that the courts might have said no but he believes and he has said that it might come in whatever form, and that is probably why you're of the opinion that anybody might want to revive this moving forward into it. Is there anything good that probably even your party leader, that is the deputy president, has said that there have been some good things that might that were in this particular document? Do you think these are some of the things that might be revived as we go into the next dispensation after 2022?
And as you respond to that, perhaps you could also provide some insight to what Kennedy mentioned at the start. We didn't only hear the name Kasavananda from the bench this afternoon. There was also the name Nelson Havi. In what context and what was the censure in regards to?
Well, I'll take the questions in the order in which they came. First and foremost, I do not speak on behalf of the party leader. He has his own view. I do not speak on behalf of the party. I speak here as a representative of the 5 individuals who presented a case to court. Now, are there any benefits that have been thrown away with the BBI bill? I think that is a discussion for another day. It will be in the realm of conjecture for us to speak about it. And I say this because the premise upon which this enterprise commenced having been found to be unconstitutional, then there is nothing useful that could remain out of it. Now, what
question by Olive?
Olive asked as to the statement by the Chief Justice. It is quite unfortunate that that statement has been made by the Chief Justice. I believe the freedom of expression and freedom of speech is one that is anchored in the Constitution, and a judge of all the people should be the last person to try and muzzle individuals from speaking. Because if that were the case, why can they speak to what Uhuru Muigai Kenyatta and Raila Amolo Odinga have said? They have said time without number that reggae was on halftime and it will come back. Is in there an inference that they knew what was going to happen? You understand? And truth be told, I did not make any disparaging remark about the court. The remark that is being referred to by the court was made by my very good friend Ahmed Nasir Abdullahi. I may have retweeted it, I may have liked it. I mean, what offense is there in liking or retweeting something? But again, did what Ahmed Nasir say constitute anything offensive? No. He said the credibility level of the Supreme Court compared to the Court of Appeal and the High Court is very low. You understand?
Yes.
I mean, you've had a judge today tell us that a popular initiative does not connote the citizen, but connotes the tyranny of numbers. You can be a judge of your own self insofar as that issue is concerned. But we must be given the opportunity to critique objectively what the judges have said. And as Lord Denning said, a judge has no function getting onto Twitter or onto the press to check what we are saying about him or her. A judge's function is to reduce his or her decision in the judgment. After that, or after his or her conduct in court, it's upon the people to evaluate. A judge cannot be immune from scrutiny and evaluation. And this is something the Chief Justice must take home today.
Thank you very much. Well, that is Nelson Havi probably giving us his views, and he believes that what has basically happened today is that is the death of the Building Bridges initiative as it has been, and he is basing it on those 2 issues that were disallowed. But remember, in their judgment, the judges in their verdict today, the judges were able to say that the basic structure is not applicable here in Kenya, but the president also cannot initiate a popular initiative, noting that his office is very sacrosanct and he cannot do that as a president. I remember even in some of those some of what was being said on the floor is that they were saying that even the resources that were used might have been public resources, just going by the functions that were being organized and the usage of the national seal and all that. But also the bill is unconstitutional. Remember, also they are saying that there was a bit of lack of public participation. And remember, all of these judges, the 7 of them, each one of them went to record their own. They went to record their own statements, and that is what they were able to bring here today. And then they were able to deduce from what everybody was able to say and say that this is what has been carried by the majority of the people.